Good day. My name is Mark Mellor. I'm an attorney with the Mellor Law Firm here. I've got a number of clients in Running Springs that are asking me issues about mechanics lien, so I thought it helpful to do a video to give you some of the particulars about mechanics lien and mechanics lien law that you need to pay attention to when looking to either enforce a mechanics lien or fight a mechanics lien that's been recorded against your property. So the first thing you want to take a look at is who has the right to record a mechanics lien. Only those people in direct contractual privity with the owner of the property have the right to record a mechanics lien unless they've sent by certified mail return receipt requested something called a 20-day preliminary notice. Now, who does that apply to? That applies to subcontractors of a general contractor or people the owner of the property is not in direct contractual privity with. If they're working on your project, what happens many of time, material suppliers, subcontractors of subs, and so forth, they need to file by sending certified mail return receipt requested to the owner, the lender of the project, and the general contractor on the project a 20-day preliminary notice. Now, that 20-day preliminary notice notifies the property owner that you're on the project working for them. It also lets them know about your contract price and so forth. That's a prerequisite to having the rights to record a mechanics lien later on if you're not in direct contractual privity with the owner of the property. If you are in direct contractual privity with the owner of the property, then you've got 90 days from the day you last worked on the project to record your mechanics lien. Unless a notice of completion of project's been filed, and then it cuts that time frame down to 30. But most of the time that hasn't been recorded and you're dealing with a 90-day time frame. But nonetheless, you've got 90 days from the day you last worked on the project. If you stopped work for a while and then came back to do some touch-up items or some finish work or whatnot, then we go by the last date you were actually working on the project. And that reinvigorates your 90-day time frame if you missed it the first time. But nonetheless, have to record within 90 days. But you're not over yet, or you're not done yet to perfect your mechanics lien. Once you record it, you've got 90 days from that recording date to file a complaint to enforce or foreclose on the mechanics lien. So if you're a homeowner, don't be too concerned just because the contractor recorded a mechanics lien against your house. The contractor has one more step to do, and that is file the complaint to enforce the mechanics lien rights against you. And many times when concerned homeowners come into my office, I tell them, well, let's just wait it out and see what the contractor does, because if he doesn't act in a timely fashion, the statute's strictly held. If he doesn't comply with those time frames, then there's a special motion that can be done in the civil code that we file to expunge the mechanics lien from the record, whether you're a property owner, a commercial property, or a homeowner. Works the same way. And we can also recover attorney's fees if we need to go through the motion filing. So those are some of the things that you have to pay attention to when dealing with a mechanics lien. If you've got a work of construction you're working on, if you're not being paid, or if you're a homeowner and you've got a contractor to record a mechanics lien against your property, feel free to come and make an appointment. I'd be happy to talk with you about your particular facts.